Good afternoon and welcome. It's my pleasure to welcome you here today. My name is Verna Williams and I am the Dean of the College of Law, and I'm delighted to be here with you today on Constitution Day. I'm going to provide a little bit of context for today, our commemoration of Constitution Day, and then I'm going to introduce our speaker, the Honorable Robert L. Wilkins. We observe Constitution Day and Citizenship Day each year to commemorate the signing of the Constitution on September 17, 1787, and to, quote, recognize all who by coming of age or by naturalization have become citizens, and that's in keeping with the congressional resolution dating back to 1940. The focal point of our celebration is a lecture by one of the nation's leading practitioners, scholars, and judges. And this talk is made possible by the generous support of Lewis Katz, who graduated from the College of Law in 1973. When Mr. Katz was in law school, he attended Constitution Day, and a program that was on Thurgood Marshall that was put on by Professor Rana Schneider. Professor Schneider arranged for this program to happen across the street at Hughes High School, and it so inspired Mr. Katz that he established a gift to honor his father, Alfred Katz, a 1935 graduate of this law school, who was born on Constitution Day in 1911. So the Katz gift recognizes Mr. Katz, recognizes his birthday, and of course recognizes the Katz family's dedication to the Constitution. We are very grateful to Mr. Katz for this generous gift. Now, today's special guest is Judge Robert L. Wilkins. He currently serves on the United States Court of Appeals for the District of Columbia Circuit, having been appointed to that position by President Obama in 2014. I remember meeting Judge Wilkins when he was an admitted student at Harvard Law School. He was a chemical engineering student looking to make a difference in the world. And since graduating from law school, he's had a remarkable career, working at the best public defender office in the nation, the Public Defender Service in Washington, D.C., working as a partner in the Washington office of Venable LLP. Judge Wilkins also was a plaintiff and co-counsel in a racial profiling case against the state of Maryland, which resulted in policies designed to curtail those practices. In addition to being a brilliant litigator and forceful advocate, Judge Wilkins is a visionary. I recall very clearly joining him and other friends at his home to discuss the idea of establishing a museum that would recognize the contributions of African Americans to this nation. It was a notion that had cropped up many, many times before over the course of almost 100 years with no success. But Judge Wilkins was undeterred. He was determined that this time around that effort would succeed, and he was right. President George W. Bush appointed him to chair the Site and Building Committee of the commission Congress created to establish the National Museum of African American History and Culture. Today, a good 3 years after its opening, admission to that museum remains one of the hottest tickets in Washington. Judge Wilkins tells the story of making this museum a reality in his book, Long Road to Hard Truth, the 100-year mission to create the National Museum of African American History and Culture. And a documentary based on this volume currently is in the works. Looking back over his accomplishments, I think it's fair to say Judge Wilkins is a Renaissance man. He's taken his bachelor's degree in chemical engineering from the Rose-Hulman Institute of Technology and his JD from Harvard Law School to make a lasting impact on law and society. And most of all, I am very proud to call him my friend, and very excited to bring him to you this Constitution Day to discuss the history of the 14th Amendment and the role of one Ohioan, John Bingham, in its drafting and subsequent ratification. So please join me in welcoming Judge Robert L. Wilkins.
Thank you all so much. And thank you, Verna, Dean Williams, for inviting me here today and for that very gracious introduction. And of course, I thank the Katz family for sponsoring this event. As she mentioned, I met Verna over 30 years ago when I visited Harvard Law School to see what it was like. And her welcoming presence was a key reason why I chose to attend. And once I enrolled, she was a great mentor to me, and for that I will always be grateful. I'd like to acknowledge and thank my mother and father-in-law, James and Ernestine Long, who are here. They live here in Cincinnati, and they came to be with us here today. I'd also like to acknowledge and thank David Meisner, sitting here in the front row, who lives here in Cincinnati. For 4 years during my childhood, when I was 10 to 14, we lived here in Cincinnati, and David was my big brother through the Big Brother, Big Sister program. He used to take me for activities and cultural enrichment and just to have fun, and we were friends then, and I'm happy to say that 40 years later, we are still friends. Thank you for being here, David. I was born about a 2-hour drive north of here in Muncie, Indiana, as was my mother and her mother, whom I called Granny Ma. I was very close to Granny Ma because she babysat my brother and I as we were growing up, and we spent many of our summers with her and my grandfather. Granny Ma used to tell me stories about her grandmother, who she called Grandma Sally. I never got to know Grandma Sally because she died in 1959, 4 years before I was born. Grandma Sally lived to the ripe old age of 84. She was born in 1875, just 10 years after the end of the Civil War. She was born in Owensboro, Kentucky, about 200 miles southwest of here, just on the other side of the Ohio River. Grandma Sally's grandmother was named Edith Salisbury. So for those of you keeping score, Edith Salisbury was my 4th great-grandmother. And she was born sometime around 1811, as best as we can tell. And she was born in bondage in Kentucky. She got the Salisbury name from the couple who owned her, Thomas and Rebecca Salisbury. The Salisburys, with the help of 25 slaves, operated a large farm outside of Greenville, Kentucky, about 4 hours southwest of this fine law school. Thomas Salisbury, the slave owner, was proud of his family name, and he made sure that all of his slaves took on that surname. My cousin, who has extensively researched the family history, surmises that Thomas Salisbury was so particular about his name that he only gave his slave Edith, my 4th great-grandmother, permission to marry if her husband would take on his family name. So David Robinson married Edith Salisbury in the early 1800s and became David Salisbury. So in the 1830s, we have an example of a husband taking the wife's name instead of the other way around, but this was hardly due to feminism or women's liberation. In 1844, Thomas and Rebecca Salisbury made a pretty momentous decision. A local historian wrote that even though they owned slaves, the Salisburys favored the abolition, the ending of this institution. And it also happens that the Salisburys had no biological children of their own. and thus no one but their slaves to pass on the Salisbury name. So they drafted a will freeing all of their slaves upon their deaths and giving their slaves all of their land. Thomas Salisbury died in 1848, and Rebecca departed this life in January 1860. Their land was divided up between all of their former slaves, and these newly freed slaves lived in a place outside of Greenville, Kentucky, that came to be known as the Salisbury Free Negro Settlement. The Salisbury name would live on, but through the progeny of the blacks who had worked the land, rather than through the biological descendants of Thomas and Rebecca. So let's pause here for a moment and capture the significance of this course of events. Edith Salisbury had been someone else's property for her entire life, and so had all of her children. We think that she had 17 children, 7 sets of twins. And now she and all of her children had agency. They were not accountable to anyone but themselves and their government. Edith, her family, and the other families on this new Salisbury Free Negro Settlement were now a part of the approximately 10,000 free blacks living in Kentucky in 1860. But were they really free? They were free perhaps from direct ownership by another human being, but were they free to enjoy all of the rights and privileges of American citizenship? What rights did the Constitution guarantee Edith Salisbury, my great-great-great-great-grandmother, and the others living on that settlement in 1860? The Constitution of the United States begins with a majestic sentence. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. But in 1860, who was included in the we the people for whom this Constitution would secure the blessings of liberty? Well, just 3 years earlier, the Supreme Court gave us its answer in Dred Scott versus Sanford, and it wasn't a favorable response to the black inhabitants of the Salisbury settlement. You see, in that famous, or should I say infamous, case, Dred Scott, a slave, had sued for his freedom in the Missouri state courts under the theory that his bond of slavery had been broken when his master moved from Missouri and took him to live for several years in Illinois and Wisconsin, where slavery was outlawed. When his master moved back to Missouri, Scott sued, relying upon the once free, forever free doctrine. And he argued that he could no longer be held a slave when his master returned with him to Missouri, which was a slave state, because he had resided for those many years in free territory. The Missouri trial court agreed with Scott, but the Missouri Supreme Court reversed, and it was up to the United States Supreme Court to render the final word. Writing for the Supreme Court, Chief Justice Roger Taney rejected this theory of freedom. The Supreme Court held that African Americans were not part of the people of the United States as described in the Constitution, and pronounced that neither the class of persons who had been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as a part of the people. The court reasoned that this was because at the time of the founding they, quote, were not intended to be included because they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges, but such as those who held the power and the government might choose to grant them. End quote. In other words, the Supreme Court ruled that the Constitution granted no rights whatsoever to African Americans, whether slave or free. Dred Scott's case was dismissed, and the highest court in the land stated unequivocally that the racist doctrine of white supremacy was baked right into those majestic words of the Constitution. So in 1860, Edith Salisbury wasn't really free after all. She might not have been a slave anymore, and she and her husband might have owned some land, but she wasn't considered a citizen of the country in which she was born. According to the Supreme Court, she wasn't even a person within the meaning of our founding documents. State law and state officials could treat Edith Salisbury in any manner they pleased, and she had no recourse or protection from the United States Constitution. In 1860, those individuals living on the Salisbury Free Negro Settlement had only as much freedom as the Commonwealth of Kentucky was willing to give them. Thus, in the 1860s, African Americans and other freedom-loving people were fighting not just to end slavery, but also to crush the doctrine of the Dred Scott decision. Blacks wanted to be citizens of these United States of America, just like their white counterparts. That's why the 24th Regiment of the United States Colored Troops carried a battle flag during the Civil War, emblazoned with the motto, "Let soldiers in war be citizens in peace." They weren't fighting merely for the emancipation of their brothers and sisters from slavery. They were fighting for citizenship. Victory would come in the Civil War, and the Union victory led to the passage and ratification of the 13th Amendment, which ended slavery. But the doctrine of the Dred Scott decision remained. Union soldiers could not defeat the Supreme Court's racist interpretation of the Constitution on the battlefield. Nor could Union soldiers defeat racist attitudes among the populace. Southern society harbored significant resentment toward the freedmen. Although black men and women constituted at least a quarter of the population in most Southern states, all classes of white Southerners were determined to keep the freedmen as nearly as possible in the same position they had formerly occupied, economically, socially, and politically. Every Southern state constitution had a provision for suffrage of only white males. Mississippi and Kentucky rejected the 13th Amendment altogether because they interpreted it to give Congress the power to enfranchise blacks, which they were never going to have. Alabama, Florida, and South Carolina qualified their ratification of the 13th Amendment by adding riders that attempted to guard against federal voting laws. As a psychological matter, many Southerners thought that slavery was the proper condition of their black residents. For instance, in the official resolution adopting the 13th Amendment, the Georgia Convention added the following caveat, and I quote, "We regard the institution of slavery as consistent with the dictates of humanity and religion. And in our judgment, the Negro race under our system of slavery has attained to a higher condition of civilization, morality, usefulness, and happiness than under any other circumstance. And we are convinced that the destruction of slavery in the South, while it is a great injury to the white race, will prove to be a great curse to the black race." End quote. Lest you think that these racial attitudes and the Dred Scott decision were only of theoretical significance to blacks, let me give you just a few representative examples of state laws that show what life was like during this time when Edith Salisbury and the others had been freed and given their land. In Tennessee, no black person had the right to vote, to hold office, or to sit on a jury. In North Carolina, no person could testify against a white person, no black person could testify against a white person unless the white person agreed to it. In Florida, if a black person working on a farm or plantation disobeyed an order, was disrespectful, or refused to work, he could be arrested for a crime. In Louisiana, a black person was required to be in service to some white person or his former owner at all times, unless he had written permission from a white person or his former owner to work for himself. And the written permission was valid for no more than 1 week at a time. These laws, known as the Black Codes, weren't the only problem. Rampant violence was used across the South to dissuade blacks from voting or fighting for their rights. Hundreds of blacks were killed by white mobs in horrifying incidents in Memphis, New Orleans, and all over the southern region. The whites were practically never held accountable in the civil or criminal courts for these actions. Indeed, sheriffs, militiamen, and other government officials often led, participated in, or facilitated the violence. Domestic terrorism against the black community was commonplace. Ending the institution of slavery was, of course, an important milestone. A system in which human beings are owned by other human beings as chattel was truly abhorrent. But replacing slavery with a status quo in which blacks were not citizens was not really freedom. Rather, it was like removing blacks from the fire and placing them in a frying pan, with the state government allowed to turn the heat up or down as much as it pleased without any interference from the federal government. One astute observer of these times said, although the former owner has lost his individual right of property in the former slaves, the blacks at large belong to the whites at large. President Andrew Johnson was of no help. He did not favor giving blacks the rights of citizenship. He once told Frederick Douglass and a group of black leaders that he would not make blacks equal to whites, that blacks themselves were to blame for poor Southern whites hating them, and that the best recourse for blacks was to remove themselves to Africa. He even vetoed several bills passed by Congress to help blacks and to grant them protection from the violence and the oppressive black codes that I just mentioned. But Congress tried to address some of this, including by passing the Civil Rights Act of 1866. This law, passed over President Johnson's veto, mandated that all persons born in the United States, with the exception of American Indians, were declared to be citizens of the United States. The legislation granted all citizens, quote, the full and equal benefit of all laws and proceedings for the security of person and property, end quote. By declaring that blacks born in the United States were citizens and indeed entitled to rights, Congress was attempting to overrule the Dred Scott decision with this new legislation. But would it work? There was a serious concern that the Supreme Court would strike down the Civil Rights Act of 1866 as unconstitutional. Indeed, the Supreme Court had just said, not even 10 years earlier, that the framers of the Constitution did not consider blacks to be citizens or a part of the we the people. So how could Congress deem otherwise? Furthermore, the act conferred rights upon blacks that would have to be recognized by the states. And most scholars at that time did not believe that Congress had the power to declare such rights. Congressman John Bingham wanted the Civil Rights Act of 1866 to be successful, but he was worried that it would be deemed unconstitutional. So his solution, amend the Constitution. Now, who was this Congressman John Bingham? John Armour Bingham was born in Mercer, Pennsylvania in 1815. His mother died when he was only 12 years old, and afterwards he spent several years of his childhood living with his aunt and uncle in Cadiz, Ohio, on the eastern edge of this state. As an adult, he would settle there in Cadiz. Bingham had strong abolitionist views, instilled in him by his parents and by his mentor and professor at Franklin College, a man named John Walker. Walker taught Bingham that the Due Process Clause of the Fifth Amendment of the Constitution should be invoked to protect the rights of blacks, which was a radical interpretation of the Constitution in the 1830s. Bingham's views were also no doubt influenced by the friendship that he forged at Franklin College with Titus Basfield, a freed slave who also attended the college, a friendship that Bingham would carry on for many years. Might I put a pencil here and note a real-life example of the power and importance of diversity in higher education. Bingham later studied law, and aided by his sharp intellect and considerable oratorical skills, he became a highly successful lawyer and politician. One example of his cunning was a case he handled early in his career, when he defended an African-American woman in a contract dispute by arguing that the only witness to the debt allegedly owed was the testimony of another African-American. And that person's testimony was inadmissible under an Ohio law that prevented African Americans from testifying in litigation involving any white person. So Bingham won his case in the Supreme Court by relying upon legal jujitsu to twist the racist law into the favor of his black client. Bingham was first elected to Congress in 1854. And he immediately made his mark with strong abolitionist speeches and his deep knowledge of the Constitution. In 1862, his role as one of the leading lawyers in Congress was demonstrated during the impeachment proceedings of a judge named West Humphreys. Humphreys was a federal judge in Tennessee who advocated for secession from the Union. He aided the rebellion, and he served as a judge of the Confederacy. Bingham was a chair of the House Managers, the lead prosecutor, in the impeachment trial before the Senate, and he was successful. The Senate convicted Humphreys and impeached him and removed him from the federal bench. Bingham enjoyed a close relationship with Abraham Lincoln. And like so many others, he was devastated when President Lincoln was assassinated in April of 1865. Secretary of War Edwin Stanton asked Bingham to investigate President Lincoln's assassination. And President Johnson later appointed Bingham to serve as a special judge advocate for the investigation and prosecution of the alleged co-conspirators of assassin John Wilkes Booth. Once again, Bingham had a prominent role, running a substantial part of the trial and giving the closing argument for the prosecution. Once again, he was successful, linking the conspirators to Jefferson Davis, the president of the Confederacy, and employing his fiery rhetoric to secure their convictions, including death sentences for 3 of the co-conspirators. Thus, by 1866, the time of this Civil Rights Act, Bingham was no stranger to the big stage, and he stepped into a leading role in the drafting and advocacy for the passage of the 14th Amendment as a member of the powerful Joint Committee on Reconstruction. Bingham approached the task with the belief that the states that had fought against the Union did not possess the rights of loyal states and should not be restored except upon conditions of security for the future, if not also indemnity for the past. He wanted the Union to require the seceded states to guarantee the privileges and immunities of the Constitution to their black residents before they could be readmitted. He took the position that the Confederate States should be required to ratify the 14th Amendment before they were readmitted into the Union, which he viewed as essential to the long-term security of the country. This position was not without political consequences because many of his constituents were wary of giving too many rights to the black residents. But Bingham pressed forward because he felt that this was the only way to ensure that neither future Congresses nor the Supreme Court could undo the intent of the Civil Rights Act of 1866, which was to declare African Americans a part of we the people, citizens of the United States. Bingham's leading role in crafting the 14th Amendment cannot be denied. Supreme Court Justice Hugo Black once stated that Congressman Bingham may, without extravagance, be called the Madison of the first section of the 14th Amendment. And the first section of the 14th Amendment is pretty doggone important. It reads as follows: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Bingham is literally the author of the Citizenship Clause, the Privileges or Immunities Clause, the Due Process Clause, and the Equal Protection Clause of the 14th Amendment. That's quite a resume. And while he may not have been a principal author of the remaining 4 sections of the 14th Amendment, he certainly played an important role. And while those 4 sections don't get as much attention, they were also critical to the reconstruction of the Union. Section 2 of the 14th Amendment revoked the 3/5 clause that had been in the original Constitution. It provided that the number of House representatives for each state would be based on the whole number of persons in the state, rather than counting whites in the states as whole persons and blacks in the state as 3/5 of a person. Section 2 also provided that if a state denied the right to vote to any male over the age of 21, then the number of representatives that it received could be reduced by the same proportion as the proportion of voters who were denied the franchise. Think about this. Counting blacks as whole persons for the purposes of assigning representation would have a huge and immediate impact. It would add over 1.5 million persons and therefore 20 congressional seats to the total House delegation of those southern states. Ironically, this provision would give the South more political power. So Bingham and others insisted that this power should not be conferred to them if the black citizens that were going to be counted as whole persons were not really truly represented. And that's why Section 2 tried to nudge the southern states towards black suffrage by threatening to reduce their congressional representation if they denied the right to vote to their black citizens. Section 3 of the 14th Amendment excluded anyone from holding federal or state office if they had held federal or state office before the Civil War and yet supported the Confederacy during the Civil War. Congress could remove that disability by a 2/3 vote, but otherwise they were excluded from holding office. Section 4 of the 14th Amendment guaranteed the Union war debt, and it prohibited the federal government from forgiving or paying any of the Confederate war debt. And Section 5, finally, gave Congress the power to enforce the 14th Amendment through appropriate legislation. Now, it would be hard to overstate the impact of the 14th Amendment because it fundamentally changed the understanding of who was a citizen of these United States, what individual rights those citizens possessed, and whether Congress had the power to protect those rights. You see, when the Bill of Rights was originally ratified in 1791, the constitutional structure was based on the assumption that the various state constitutions would be the primary protectors of individual rights, and that state residents would be protected by those state constitutions. So at the founding, when the Bill of Rights were ratified, the purpose was to protect citizens against infringement of their rights by the federal government. But now, with the passage of the 14th Amendment, the Congress would protect individual rights and against infringement by the states. As stated by historian Richard White, and I quote, "The broad principles of the 14th Amendment were clear. The Republicans sought to abrogate judicial interpretations of the Constitution that in the name of federalism had limited the extension of a uniform set of rights applicable to all citizens everywhere in the Union. Congress intended that the new amendment to extend the guarantees of the Bill of Rights so that they protected citizens against actions by the states as well as by the federal government. The Equal Protection Clause was supposed to ensure that no state discriminated against its own citizens or against the citizens of another state, and the amendment would also protect both new black citizens and white Unionists who traveled to the South. The Republicans desired a national citizenship with uniform rights. Ultimately, the amendment was Lincolnian. It sought, as had Lincoln, to make the sentiments of the Declaration of Independence the guiding light of the Republic. It enshrined in the Constitution broad principles of equality, the rights of citizens, and the principles of natural rights, prominent in the Declaration of Independence and in the Republican ideals of free labor and contract freedom." End quote. In sum, the 14th Amendment changed the federal-state relationship as well as the relationship between the federal government, the state government, and their citizens. It was such a sea change that some scholars refer to the 14th Amendment in combination with the 13th Amendment and the 15th Amendment, which extended the right to vote to blacks, as marking the second founding of our great nation. But because of the changes it foretold, the vast majority of Southern white residents detested the 14th Amendment. That included the occupant of the White House, President Andrew Johnson, who argued against its ratification. But the Republican Congress forced the issue. They used their legislative power to essentially declare that a Southern state would not be readmitted into the Union unless it ratified the 14th Amendment, unless the state convened a constitutional convention to rewrite its state constitution, and unless that state included provisions in that new state constitution permitting blacks to vote. The 14th Amendment wasn't universally loved in the North either. Several Ohio newspapers vilified Bingham for his role in the endeavor. And after approving the amendment in 1867, the Ohio legislature actually voted to rescind its approval in early 1868. U.S. Secretary of State William Seward deemed the rescission invalid and counted Ohio's vote anyway towards the 3/4 of states necessary for ratification. So with the votes of both willing and reluctant states in the North and in the South, the 14th Amendment was ratified and went into effect on July the 9th of 1868. I have to say that I was quite dismayed to learn that Ohio's vote to rescind its approval of the 14th Amendment while I was doing the research for this lecture. Did that mean that the Ohio legislature still questioned whether I was worthy of citizenship or worthy of the equal protection of the laws? But my faith in the Buckeye State was restored because I discovered that largely due to the push by University of Cincinnati College of Law professors Gabriel Chin and John Cranley, along with their students, the Ohio legislature re-ratified the 14th Amendment in 2003. So bravo, University of Cincinnati College of Law. I've wondered what practical effect the 14th Amendment had on the lives of the former slaves living on the Salisbury Free Negro Settlement, including my fourth great-grandparents, David and Edith Salisbury. I've tried to imagine what it must have felt like to go through life for so many years as someone else's property, then to become a supposedly free person, but with limited rights, and then to be deemed a supposedly full citizen with all the same rights as any black person. Did the 14th Amendment really make a difference in their day-to-day existence? Did it give them any comfort or protection? I feel like I will never know, but I certainly hope that it did. They certainly deserved it. I take some solace from the page that I saw in the 1870 census record from Muhlenberg County, Kentucky, where David Salisbury's name appears. You see, as a means to ensure compliance with the newly enacted 14th Amendment, the census takers in 1870 asked every household whether any males over the age of 21 had been denied the right to vote. The census taker wrote no in response to that question next to David Salisbury's name. Seeing that gives me some hope that David Salisbury was able to vote, perhaps for the first time in his life during the 1870 elections, and thus have a say, perhaps for the first time in his life, in his own government. I have a little bit clearer evidence that the 14th Amendment had a real practical effect on David and Edith's granddaughter, the woman I introduced to you at the beginning of my remarks as Grandma Sally. As I mentioned, Grandma Sally was born in 1875, and she would have been elementary school age in the early 1880s when she was growing up in Owensboro, Kentucky. At that time, Owensboro schools were funded under a law that required taxes collected from white taxpayers to support schools for whites only, while schools for black students were funded from taxes collected from black taxpayers only. Because the black population was both smaller in number and owned significantly less property than the white population, there was a large disparity in funds available for the black schools as opposed to compared to the white schools. As a result, there was a large disparity in the black and white school systems. The white students had 2 excellent school buildings, plenty of books, about 1 teacher for every 44 students, and a 9-month school year. The black students had 1 dilapidated school building, 2 few and inferior books, 1 teacher for every 167 students, and a 3-month school year. Black parents in Owensboro petitioned the school officials to either make more funding available for the black schools or to allow the black students to attend the white schools. The officials did neither, so the black parents sued in federal court in 1883. In a landmark decision, Judge John Watson Barr ruled that the separate funding scheme violated the Equal Protection Clause of the 14th Amendment, because while the amendment did not require absolute equality in distributing the benefits of taxation, he reasoned that it did require the distribution of the benefits upon some fair and equal classification or basis. This lawsuit, called Claybrook versus City of Owensboro, would be cited 50 years later by Charles Hamilton Houston and Thurgood Marshall in the campaign by the NAACP for equal school facilities for blacks and whites, in the litigation that laid the groundwork for Brown versus Board of Education. Following this ruling, a new school building was constructed for the black students in Owensboro. And even though the resources for the black students were not made completely equal to those for the white students, I guess I take some solace imagining Grandma Sally walking into that new school building for the first time, perhaps with a grin, as she enjoyed a new and improved environment in which to learn. I have even better evidence of the practical impact of the 14th Amendment on the life of Grandma Sally's granddaughter, the person I introduced to you at the beginning as my grandmother, who I called Granny Ma. She was born in 1923, during the Jim Crow era of segregation and second-class citizenship. But she lived to see that 1954 decision in Brown versus Board of Education, which led to the dismantling of Jim Crow in all of its various forms and enabled her to send her children to integrated public schools. Later, in 1971, as Granny Ma reached middle age, the Supreme Court finally embraced women within the 14th Amendment guarantee of equal protection under the laws in the case of Reed versus Reed. She was able to see many gender barriers fall as more and more opportunities opened up for women in every field of endeavor. I have my own firsthand experience with the 14th Amendment. In 1992, while en route back home from my paternal grandfather's funeral in Chicago, I and 3 family members were stopped and detained by the Maryland State Police. The state trooper claimed that he stopped us for speeding, but rather than simply writing my cousin a ticket, he pressed us for permission to search our car. When we declined, asserting our rights, he responded by saying that if we had nothing to hide, then what was our problem? I asked the officer what justification he had for wanting to search our car, and he said something about problems with rental cars coming up and down the highway carrying drugs. I told him that there should be nothing suspicious about driving a rental car on the highway. I explained that we were coming from my grandfather's funeral and that we were driving all night so that we could get back to our homes and jobs in Washington, D.C. and Virginia. I told the officer that if he did not believe me, I could get a copy of my grandfather's funeral program from the trunk. He said, "I don't want to see any funeral program. I want to search the car." So despite the fact that I told him that he was violating a precedent set in a 1985 U.S. Supreme Court case called United States versus Sharp, by detaining us without reasonable articulable suspicion that we had committed any crime, the trooper detained us so that they could carry out this search by a drug-sniffing dog. So 30 minutes later, there we were, standing outside our car in the rain, lined up along the road with police lights flashing, officers standing guard, and a German shepherd jumping on top of, crawling underneath, and alongside every inch of our vehicle. We were criminal suspects, even though we were just trying to travel from our homes to a funeral and then back home again. I particularly remember a car driving past with two young white children in the back seat, noses smushed against the window. They were looking at the policeman. They were looking at the flashing lights. They were looking at the German shepherd. And then they were looking at us. I felt that those children, upon viewing that spectacle, likely concluded that these black people standing along the road certainly must have been bad people who had done something wrong. For why else would the police have them there? Those children were being miseducated about me and about black people in general by this spectacle. But as I was standing there in the rain, there was nothing whatsoever that I could do about it. The dog sniffed everything, but it never barked or did anything unusual. They finally let us get back into the car. The officer wrote my cousin a $105 ticket, and we were told to go on our way. A few months later, represented by the Maryland ACLU and a law firm called Hogan and Hartson, which is now known as Hogan Lovells, we filed a lawsuit that was called Wilkins versus the state of Maryland. The lawsuit alleged that the traffic stop violated the Equal Protection Clause of the 14th Amendment and various federal statutes that Congress had enacted to ban racial discrimination pursuant to the power that the 14th Amendment gave Congress. Shortly after we commenced discovery in the lawsuit, we got a very interesting document from the files of the Maryland State Police. The document was called a Criminal Intelligence Report. The Criminal Intelligence Report had been sent out to the troopers in Cumberland, Maryland about 2 weeks before we were stopped and searched. It discussed the crack cocaine problem in the area, and it recklessly and indiscriminately advised state troopers that the drug traffickers were, quote, predominantly black males and black females, end quote, and that these dangerous armed traffickers generally traveled early in the morning or late at night along this stretch of the interstate, and that they favored rental cars with Virginia tags. Well, we fit their profile to the T. We were traveling on the interstate early in the morning in a Virginia rental car, and my cousin and I, the occupants of the front seat, were black males. The only problem was that we were not dangerous armed drug traffickers. So we now had evidence written down for everyone to see that the Maryland State Police had a written policy to target black drivers. We had written proof of racial discrimination in violation of the guarantee of equal protection of the laws. We had a smoking gun. We used that proof as leverage to extract a very tough settlement from the Maryland State Police. Yes, they gave us some money, but we negotiated for a whole nother year to get them to agree to new policies and procedures that the state police would be required to implement as part of this settlement. It required them to enhance training and most importantly, to begin a systematic effort statewide to compile and publish for us data of all of their highway traffic stops and searches, the race of the people involved, the reasons for the searches, and what, if anything, was found. Once we began receiving that data in 1996, it showed something very interesting. It showed that for every 100 white motorists who were stopped and searched, there were approximately 400 black motorists who were stopped and searched. But the other interesting fact was that if 100 whites and 100 blacks were searched, they found drugs the same amount of time, or perhaps even lower for the black motorists. So that raised a question. Why was the war on drugs being fought with 4 times the intensity against black motorists than white motorists? And that lopsided enforcement had consequences, right? Because that meant 4 times the arrests, 4 times the convictions, 4 times the prison sentences, 4 times the disenfranchisement, 4 times the loss of employment, and 4 times every other consequence and residual effect of criminal prosecution. These were real consequences, and this was not equal protection of the laws. So this data led us to file a second lawsuit against the Maryland State Police. And in 2003, we settled that second lawsuit, and the state police agreed to continue the data collection and to implement more rigorous reforms, like placing cameras in all of their vehicles, enhancing supervision and community involvement, and making their complaint and disciplinary systems more transparent and accountable. When that second settlement expired in 2008, the disparity in searches of black and white motorists had decreased from 4-to-1 to 2-to-1. So just as the Owensboro school lawsuit didn't result in complete equal treatment for Grandma Sally, we didn't reach our goal of complete equal treatment either. But at least I take some solace in the fact that we made tangible progress towards that goal. And I think that we helped to prevent a lot of unlawful detentions and searches during the process. Now, of course, that is not my only experience with the 14th Amendment. Just as it has impacted each of you, the 14th Amendment has impacted my life in myriad ways. While the journey of the 14th Amendment may have begun primarily as a quest for African American political representation, voting rights, and freedom from discrimination, the 14th Amendment blazed a trail for the granting of rights to countless other individuals and groups fighting against discrimination, whether based on gender, ethnicity, national origin, disability, or sexual orientation. Without the 14th Amendment, Edith Salisbury would never have been able to make the transition from slave to citizen. Her granddaughter, Grandma Sally, would never have been able to experience that new school. Her granddaughter, my Granny Ma, would never have been able to see the death of Jim Crow. And her grandson, me, I would have never been able to see the election of the first black president of the United States and receive an appointment to the federal bench. None of this would have been possible without the 14th Amendment. In 6 generations, we went from slaves with no rights to a federal judge with the power and responsibility to enforce the rights. So on this sesquicentennial of the 14th Amendment, each and every one of us has a responsibility to make sure that we do not take it for granted. Too many lives have been lost. Too many tears have been shed, and too many miles have been marched to turn back now. Thank you, John Bingham, for your pivotal role in the second founding of our great nation. And thank you, University of Cincinnati College of Law, for the honor of inviting me to give your Constitution Day lecture on this afternoon. Be ever vigilant and keep the faith. Thank you.